Well, good afternoon or good evening or good morning or good whatever time it is, wherever you are. Thank you for joining us today for our program. My name is Tom Giovanetti. I'm the president of the Institute for Policy Innovation. And I would like to welcome you all to our 15th annual World IP Day briefing. This one, of course, is a little different than those in the past. Normally, this is an event that is held live in Washington, D.C., and we're sorry we don't get to see all of our friends and regular attendees in person this year. But on the other hand, because of the silver lining is that it's available to people that are outside of DC, and we have folks from all over the country and all over the world with us today. And so we're delighted that you could all join us today. Our discussion today is entitled Patents and the Pandemic. And this is obviously a very relevant topic for today and very imminent. As celebrants and of champions of intellectual property and of the patent system, we think it's clear that the existing patent regime and all of its incentives has created a strong, innovative biopharma industry that was ready to move at a moment's notice toward researching treatments, tests, and vaccines. Incentives did not have to be put into place. They were already in place. Governments did not have to act. Legislatures did not have to pass new laws. Price systems did not have to be developed and implemented. The incentive structure was already in place for such a time as this. But there are also opponents of the patent system who would like to use the pandemic as an opportunity to argue that the patent system is actually a barrier to rapid discovery and innovation, as well as a barrier to distribution of medicines and treatments once they become available. So those are some of the topics that we want to talk about today. We have a very distinguished panel of guests who are going to be helping us toward that end. Let me do a little Zoom housekeeping first for those of you who may be new to the platform and are not yet burned out on Zoom. You can turn off your video as you like. You can turn it on, you can turn it off. You can choose to view the speaker in a larger window by choosing the speaker view in the upper right-hand corner of your Zoom software. In the upper right-hand corner of your video window, you can choose Raise Hand, which is how we will acknowledge folks who want to ask questions toward the end of each presentation. There is a chat window in the Zoom software, but I will be ignoring it, and we will not be taking questions through chat. So if you want to ask a question, you'll have to raise your hand through the Zoom software and ask it in that way. We will only take a very few questions today in order to keep this briefing as short as possible. We recognize the phenomenon of Zoom fatigue, and we don't want this event to go on any longer than is useful to all of you. And now I will move toward recognizing our first speaker for today. And as I do so, I will endeavor to unmute his microphone. There we go. We're delighted to have with us again this year, John Sandage. John is in Geneva, Switzerland today. He is the Deputy Director General of the World Intellectual Property Organization, where he oversees the patents and technology sector. That includes managing the PCT, International Patent System, which is very important, the Arbitration and Mediation Center, the Standing Committee on the Law of the Patents, and his department also provides legislative advice to WIPO member states. So Deputy Director Sandage, we are delighted to have you with us today, and we would love to hear from you about how things are going at WIPO, how WIPO is functioning in the current situation, and any other nuggets of wisdom you have for us today.
Thanks, Tom, and greetings, everyone. Live from Geneva, here we are, World IP Day. I am not going to say anything about the given theme for the day because I think in light of changed circumstances, as Tom's indicated, you'd like a more practical report on what's going on with the PCT and WIPO. I will just note that we're about 5-6 weeks away from the 50th anniversary of the adoption of the PCT. That will be in June, and it's come a long way in 50 years. If you were to look at a chart that shows you the growth in the PCT over that 50 years, it's a beautiful parabola. There was one dip in 2008, 2009 when the world economy wobbled. We don't yet know what the graph will look like for 2020. Undoubtedly, there'll be another wobble, but we at this point don't have any sense of what kind of fall off there will be in the use of the PCT this year. We only know that there will be. That's because PCT applications don't show up in the international phase here at WIPO until about 12 months after they've been filed in the national phase. And so we will be waiting to see. It'll be a lagging indicator, but we do expect there'll be a fallback. Nevertheless, in 2019, the PCT once again showed growth of over 5%. 2019 was also a very significant year in the life of the PCT because for the first time in 50 years, the US is not the leading user of the PCT. China overtook the US to become the biggest filer under the PCT. 22.2% of PCT applications come from China, and the US is behind by 0.4%, 0.4% at 21.8%, and then not very far behind is Japan at 19.8%. If you take those three countries, you have 64% of all PCT applications from those three countries. If you kick in the next two, which are Germany and the Republic of Korea, you get to 78%. And if you include the top 15 filers, you're at 93%. So the PCT is very much, applications come principally from Asia, from Europe, from North America, much fewer from Latin America or from the African countries. Now, let me turn to what's going on at WIPO in light of the coronavirus epidemic. WIPO is open for business. All of the platforms and services are fully functional, but we are all working from home. The campus is essentially closed, and this is quite a change for WIPO. We have never before allowed staff, especially the staff of the PCT, to work from home because of concerns about the possibility of hacking. Nevertheless, when the decision was taken by the Director General to send everybody home, we very quickly transitioned to the new arrangements. Within 2 weeks, the PCT was operating at 89% of capacity, and now we're about 6 weeks into this, and we are basically at 100%. If you are interested, you can go to the WIPO webpage. We have put up what's called a crisis management dashboard, and it will show you on a real-time basis, it's updated every couple of weeks, how the platforms are doing. At this point, the PCT still shows at 89%. That was in the first couple of weeks, but we're now essentially at 100%. It's the same for the Madrid system, for the Hague system. We had a backlog that built up in the first 2 weeks in processing applications because we didn't have our staff working at full tilt. They are now at 100%. That backlog is steadily being whittled back down. So from your perspective, using the PCT should be seamless. You should not be detecting any real changes in how the system works for you. And I should also mention that we closed out the fiscal year 2019 with 100 million franc, which is essentially $100 million surplus. So WIPO is in a very healthy state. If there is a fallback in the filing of applications under PCT or Madrid or The Hague, we may have reductions in revenue, but we are well able to carry the costs of the organization while we wait for that to come back. We have taken a number of steps at WIPO to try to respond to the specific circumstances that the user community are facing. As I said, the PCT, the International Bureau, is open for business. Most PCT receiving offices are open for business. If you want to see which ones are not, you can go to the website. We've got a matrix that lays that information out. Nevertheless, there's been a lot of disruption of postal and private delivery services. The mail is coming into Switzerland only from a limited number of countries. So we have had to announce, which we did on March 30th, that we were suspending the receipt of PCT documents and the sending of PCT documents on paper. And so we're now transmitting documents only electronically. So we have sent messages to all the user community for whom we did not have email addresses. We were picking up that information, and there have been equivalent measures taken by the Madrid and Hague systems. We are well aware that the user community is facing a number of questions about how and whether they can bring their applications forward under these circumstances. One of the questions that we have had put to us repeatedly by the user community is the priority period under the Paris Convention. Under the convention, the priority period is only extended if the filing office is declared itself closed. And the IB is open, most national IP offices are open. And so the priority period remains as it normally would be under the Paris Convention. We have asked some of our lawyers to take a look at the convention to see whether legal theories might be available that would provide for some more flexibility in the application of the Paris Convention, both in respect of priority period and in restoration of priority rights. We don't yet have answers to that, but we are actively looking at it. I'm hopeful that we will be able to issue some sort of an interpretive statement on that point in the near term. All of these things are on the WIPO webpage, and as we issue announcements, issue interpretive statements, they're all there. For example, the Director General has issued an interpretive statement on the PCT Rule 82 Quater, which is having to do with the excuse of delay in meeting time limits due to such things as natural calamities or other similar circumstances. And we have announced, the Director General has announced that we will interpret the PCT Rule 82 Quater to treat such requests favorably, and that we will not require specific proof of local impact of the coronavirus for a particular user. We will also delay declaring applications to be considered to have been withdrawn. For example, if fees are not paid within time limits, and we're not going to be charging late fees for late payments. Again, all of these are up on our website, and it's explained in considerable detail. And the Director General has also issued a statement encouraging all national offices to take a similarly liberal view of excuses for delay. Tom mentioned in his opening that I think there are a number of stakeholders to the patent system who regard the current crisis as an opportunity and who are raising questions about whether or not the patent system is an impediment to dealing with the crisis, and by therefore arguing that perhaps we need to think about temporarily suspending some of the patent protections that the PCT and other patent systems normally provide. The Director General has actually issued a statement on this. Again, it's on the web page. It's called Some Considerations on Intellectual Property Innovation, Access, and COVID-19. And what he is saying basically is that the main challenge at the present time is not access to vaccines, access to treatments or cures for COVID-19. The main problem we have right now is the absence of any approved vaccines, no treatments, no cures to have access to. And so the policy focus on governments at this stage should be on supporting science, on supporting innovation, to come up with vaccines, to come up with drugs. And we can leave for a later time when those inventions, when those new innovations have presented themselves, how the patent system should handle them such that they can be made broadly available to the international community. So the Director General has laid all of this out. It's on his own motion. It's not with the permission of the member states, but because he was getting so many questions and letters wondering about whether or not the rules of the patent system should be suspended, he felt it was appropriate for him to make that statement. I know I'm running out of time, Tom. I wanted to just mention that we have made some adjustments to patent scope. So there's a new search functionality if you want to find inventions and technologies that are relevant to the COVID-19 pandemic, they're now easily found. I will wrap up just by reminding everybody that there was in March, there was a decision taken by the Coordinating Committee of WIPO to nominate Darren Tang of the IP Office of Singapore to be the next Director General. He will have to be confirmed by the WIPO General Assemblies on May 7th and 8th. We have, with the agreement of member states, decided that there will not be a physical meeting on the 7th and 8th. It will be a paper meeting. Member states will be invited to indicate their views on Darren's nomination in writing. And we expect that next week, on the 8th of May, Darren will be proclaimed the Director General-elect, and he will take office on October 1st at the conclusion of the General Assembly. I think I've gone on long enough. I had a few more points, but I think I've gotten the main ones across, and I know Tom has a lot of ground to cover, so I'll leave it there. Thank you.
Thank you, John. That was terrific, and I do appreciate you operating within our time constraints. And I want to mention to the audience that you've got about 15 seconds if you want to ask a question of Deputy Director Sandage. You got about 15 seconds to raise your hand under the Zoom raise your hand functionality, and I will see that. John, I just wanted to thank you in particular for making that point you made about the Director General's letter, explaining that there is a difference between the incentives for producing things and then discussions about how we distribute them.
Right.
Because it seems to me that this is one of the major areas of conflict and confusion in intellectual property, is that the system that is, you can't distribute something unless it exists in the first place. And
That's
so
right.
many of these arguments and discussions are about how we distribute creative goods and creative works, but how we distribute them, how we pay for them, that is a totally separate area of discussion from how we incentivize their creation in the first place. So I'm glad you mentioned that. I'm glad that the Director General addressed that, because I think that's really crucial. And John, you must have done an excellent job, because there are no questions. So I will thank you. I will thank you for joining us from Geneva. I will wish you well in the impending storms there that you're apparently dealing with, and I will be delighted to transition to our next speaker, who is Adam Mossoff. Adam is a longtime friend of, is a longtime personal friend, and he's a longtime friend of IPI. Adam is a professor of law at the Antonin Scalia School of Law at George Mason University. He is also a fellow with the Hudson Institute for Intellectual Property. In fact, his title is Senior Fellow and Chair of the Forum for IP with the Hudson Institute. Adam has spoken at some of our World IP Day events in the past. He's a creative and interesting speaker. And Adam, I'm delighted you were able to carve out some time for us today. So without any further ado, let me turn things over to Adam Mossoff.
Thank you. And you can hear me, Tom?
Yes, very well.
Excellent. And again, and thank you for inviting me to participate in this panel discussion. You should be thankful that you are not in Washington, D.C. right now, because it is very rainy and cold. So at least you are nice and dry and warm and feeling good in your home in Texas, and everyone else in their own homes. I will defer and leave to the experts on the ground, Corey and Justin, as to kind of the details of what's happening in the industry and what they are doing in creating innovation and securing that innovation through our legal system and through patents. As the academic, I want to kind of provide a framework for how we should be thinking about these issues, kind of establish a baseline for thinking about what are patents and how patents have functioned, especially in the biopharma industry, and really making modern life a veritable miracle, and making it possible for the biopharma industry to respond to the coronavirus in a way that no human society ever has in history, and thus ensuring that the pandemic of 2020 will not be a repeat of the Spanish flu pandemic of 1918. So first of all, I just want to kind of establish the basis for what we're talking about, which of course is patents. And there's a lot of confusion about patents. People claim, and a lot of people assert these are monopoly grants. This is issued by the government for public regulatory purposes and things of this sort. And yes, I mean, that has been part and parcel of the broader policy debates about the patent system. But the United States did when it first set up its patent system, starting in 1790 under the Constitution and running through today, is that it created actually a property rights system. On the grounds that the same justification that if a farmer will invest their time for a year in tilling the soil and husbanding the soil and harvesting the crops, and then engaging in transactions with middle persons to take those crops to the marketplace, to sell them in a town, to reap the fruits of their labors is the classic metaphor. We do the same thing with inventions, that inventive labors are productive labors, and that in fact a farmer can't do what farmer does without inventors conceiving of the tools and methods of how to husband crops and creating the mechanized reaper and the tractor by John Deere and all of the various implements that have made modern society possible. And we are the beneficiaries of this insight. That, as President Abraham Lincoln famously said, the patent system added the fuel of interest to the fire of genius, and it inspired people to not just create new innovations, because you can incentivize people to create through lots of different mechanisms. You can do that through regulatory grants, through promises of monopoly protections, through prize systems and everything of that sort. But through a property rights system, you not only incentivize people to create, you create the basis, as we see in every other area of our society and our economy with property rights, for people to engage in transactions, to create both the commercial mechanisms and the distribution mechanisms necessary for getting products and services into the hands of consumers. And thus, patents don't just incentivize people to create, they serve that very important key bridge as a property right that bridges the lab to the marketplace by making it possible to create the supply chain, the value chain, and serving as the basis for the contracts, creating the infrastructure, commercial infrastructure and capital infrastructure necessary with follow-on investments in that infrastructure to then distribute products in the marketplace and get them in the hands of individuals. And this is exactly what the patent system has achieved. It achieved it at the very start of our country with the Industrial Revolution, as people created new and miraculous new types of devices, as I mentioned, the mechanized reaper and the telegraph and things of this sort. And it did it again with the birth of the modern biopharmaceutical industry in the early 20th century. Once at the end of the 19th century, what was then the atomic theory became actually the model for the basics of matter. The periodic table of elements was accepted in chemistry. You had an explosion of discoveries and innovation in discovery of molecules and basic organic compounds that can treat humans and the various maladies, so that we aren't killed by viruses and bacteria on a day-to-day basis the way that humans have been for hundreds of thousands of years. And what we now have today as a result of this is an incredible, innovative, flourishing sector of our economy that has made, as I said, modern life a veritable miracle by any historical standards that one would want to apply. And this is the result of incredible scientists and business persons putting incredible effort and massive amounts of capital and money and time into the creation of new products and services, given the same promise to them of a property right that a farmer has a promise in the fruits of their labors when they work for a year or more in creating crops to sell in the marketplace as well. And so in fact, the biopharmaceutical industry today exemplifies exactly the type of creative investments and innovative labors that one expects to see in any area where people are promised the fruits of their labors. And there's a lot of confusion about this. So a lot of, for instance, claims that, well, this government should step in and should impose rate regulation or compulsory licenses, or just take patents because this is the product of public funding in the first place. A lot of people think mistakenly that most innovation is the result of public funding, and the exact opposite is in fact the case. In 2019, you had over $129 billion that were invested in life sciences research and biopharmaceutical research by private companies and private organizations. This is more than 3 times the amount of public funding provided through the National Institutes of Health. And this is what drives the innovation. that we have seen. And this type of investments are necessary. The economists at Tufts University have confirmed that the average cost of R&D expenditures that are behind a successful drug being sold in the healthcare market is approximately $2.6 billion. I mean, so that's $2.6 billion that a particular company or set of companies has invested before they've seen a single dime in recouping that investment. And that it takes upwards of 10 to 15 years to spend that money to come up with the particular molecule or drug or vaccine that will then be deployed in the marketplace. And as a result of this, as I mentioned, we have incredible treatments today for diabetes, for cancer, for many things that were used to be, even 10, 15, 20 years ago, were death sentences for people, are no longer death sentences, are manageable conditions thanks to the efforts of this industry, and that the fruits of their labors are secured to them through reliable and effective patent rights. And it's very important to recognize, I think, that this is not the first time that we've experienced crises, health crises or otherwise, even in the modern era. This is the first time we've had a serious pandemic of the sort that we're experiencing now. It's unlike prior pandemics like with H1N1, the bird flu, and SARS, which were pandemics as well, but not as large. But we had the AIDS crises in the 1980s and 90s, and there were similar calls for march in and taking the patents and compulsory licensing at that time. And I think the government rightly recognized that it shouldn't do so. And it was important because that continued to incentivize people to make the investments to come up with the innovations and the treatments that have made now AIDS a manageable life condition, as well as to continue to incentivize them to create and develop the mechanisms commercially and otherwise to deploy those treatments and drugs in the marketplace to the benefit of everyone's lives. And we should continue to do so today through our current crisis. So I think that's just kind of thought I would provide a nice framing for what I think will be incredible information and details and data from Corey and Justin. Thank you, Tom.
That's great, Adam. Thank you very much. If you have a question for Adam, again, you can go up to the top right-hand corner of your little video box and you can click on raise hand, I think is how it's phrased. And I will see that you have raised your hand and I will acknowledge you. Adam, I want to ask you a question. I made a point in my introductory comments that we didn't need to create an incentive system to deal with the COVID-19 virus because we already had one in place. Mm-hmm. But you've actually done a lot of writing and speaking about the fact that in recent years in the U.S., we've actually allowed our patent system to erode a bit.
Yes.
And we have undermined some of the incentives in the U.S. for innovation. Deputy Director Sandage mentioned that China has now surpassed the U.S. in the number of patent filings, mm-hmm. which, if not a direct index of innovation, is at least an indirect index of innovation. So could you talk for a couple minutes about some of the ways we've shot ourselves in the foot in the U.S. in recent years on our patent system?
Yes, thank you, Tom. It's a great question, and it's a very important question because the United States used to be the gold standard of patent systems around the world. In fact, we set the basis by which many countries copied our system to ensure and provide reliable and effective property rights protections in new innovative technologies and processes. And in the past 10 or 15 years, the U.S. Patent system has been put under an incredible amount of institutional stress through decisions by the U.S. Supreme Court, by regulatory actions, by the antitrust authorities, and even through legislation enacted by Congress. And the result has been an evisceration of the reliability and effectiveness of our patent rights. So patent owners are unable, for instance, to reliably obtain injunctions in order when they are facing direct infringements of their property rights, in the same way that any other owner of a valuable asset, a homeowner or a business, can stop someone from taking their property or using their property without their permission. And that's even if you obtain a patent, that you can't get an injunction. It's become very difficult to then license that patent. The Supreme Court has handed down various decisions, which has made it very hard to enter into the marketplace with your property right and to get the fair market value for what you have created and to recoup your $2.6 billion in investments. And even more importantly, that's, again, if you have your patent, many times you can't even get your patent now because the Supreme Court has recently decided that we should be very restrictive about what types of innovations are protected, and this has impacted, in particular, the biopharmaceutical sector in a really, really, really harsh way. So classic drugs, treatment, and diagnostic methods, tests. For instance, a lot of people are talking today about the need for tests. Well, that's diagnostic tests. These things have to be created, and they're a byproduct of incredible amounts of effort and massive investments. And and today, under very willy-nilly decision making by courts and sometimes by the U.S. Patent and Trademark Office, people are having their patent applications denied, and even when those patents issue, courts are invalidating them left and right. And in fact, tens of thousands of patent claims have been invalidated for being unpatentable, not true inventions or discoveries, even though these are kind of classic innovations that have been recognized and protected. Classic drugs, molecules that are in drugs that treat cancer and diabetes for decades and decades are now being held to not be patentable, either in the applications at the Patent Office in the U.S. or courts are invalidating them. And then the result of this, as you would expect, is one is seeing a decrease in venture capital investment in these areas, and also venture capital is flowing in our global digital economy to other countries, such as China, that actually provide much more reliable and effective protections. So we now see, and this has been measured and proven, that venture capital is now moving to China. They're doing more actual drug tests and research in China, and you can get things like an injunction once you get a patent in China as well as receiving patents on these issues. Thus, that being the source where the property right exists, that being the source where the economic activity will occur, replicating what happened in the United States in the 19th and 20th centuries.
Is the solution to that, Adam, waiting for the courts to change their mind, or do we need legislation?
It could be a combination of both. The hope would be that the Supreme Court would change its mind. Unfortunately, they've shown no indication that they understand that they have misinterpreted the patent statutes. But thankfully, because the Supreme Court is only interpreting the statutes that Congress has enacted, then it's very easy for Congress to step in and to enact legislation to reverse these decisions and to say, you've misinterpreted the laws that we have enacted. This has happened many, many times in the history of our country, where Congress has stepped in and said a court decision misinterpreted the patent laws, and so we're overruling it. And in fact, there are several bills that have been introduced in Congress: the Stronger Patents Act, the Raleigh Act, Restoring American Leadership and Innovation Act. And there was a lot of discussion about introducing a bill to secure, and to reverse these decisions on what counts as patentable inventions. And unfortunately, that hasn't made it to a bill stage, but these discussions are ongoing, and Congress should actually act on these matters, yes.
All right, thank you, Adam. I appreciate that.
Yeah.
I will now introduce Dr. Merrill Matthews. Dr. Matthews is a resident scholar with us here at the Institute for Policy Innovation, and I will count on Dr. Matthews to moderate the rest of our program. Dr. Matthews, your microphone is unmuted, so go ahead.
Thank you, Tom, and thank you all for joining us. I'm going to introduce two of our speakers who will be talking about pharmaceuticals. They're from the pharmaceutical industry, and it is amazing to see what has happened in the pharmaceutical industry and the attitude towards it. The pandemic has taken us to a complete turnaround where for years the innovative companies, pharmaceutical companies, have been painted as a pariah and everything that's wrong with the healthcare system, to some of these same pundits, media, and politicians hoping and praying that they will save our lives and our economy from the coronavirus. So it's just amazing to see what's happened there. Our first speaker from the industry, Corey Salzberg, he is Vice President of Global Head of IP Affairs at Novartis. He has testified before the United States Senate Judiciary Subcommittee on IP on the state of patent eligibility law in the U.S. And as I mentioned, he comes from Novartis, and Novartis is one of the early entrants into this fight. Back in March, they announced that they would be donating 130 million pills of hydroxychloroquine for clinical trials and other uses. On March 30th, they announced that 30 million of those tablets would be going to the U.S. Department of Health and Human Services. And on April 20th, Novartis announced that it is entering a large clinical trial. I assume this is probably a phase 3 trial of hydroxychloroquine in hospitalized COVID-19 patients. That's important because we've had a lot of anecdotal evidence that hydroxychloroquine works, but we don't have any clinical trial evidence yet. So I'm going to turn it over to Corey to take us through what Novartis is doing.
Great. Thank you very much, Dr. Matthews. And I want to do a special thank you to Adam also for wearing a tie and making the rest of us look bad. So look, there's an old joke, you may know it from the Woody Allen films of the past. A guy walks into a psychiatrist's office and he says, "Hey doc, you got to help me. My brother's crazy. He thinks he's a chicken." And the doctor says, "Well, why don't you just have him committed?" And then the guy says, "Well, I would, but I really need the eggs." You probably know that one. But you know, we're in the middle of a pandemic here, and I think the one thing everyone can agree with is that we really need the eggs. And while our industry and others pour our resources into the innovation and the collaboration that's going to get us those eggs, as many have mentioned, unfortunately, we have some that want to take away the very system that makes it possible to develop them and have that system committed. So especially in times of crisis, what I want to do here for the next few minutes is go through the facts, because I think it's really important that we operate on facts. And the facts are that the patent system is enabling innovation and collaboration at record speed and at unprecedented levels to tackle this pandemic. And it will also work, contrary to what some are saying, to enable fast and broad access to the treatments that come out of it on the other end. So let's turn to some of those facts. As a starting point, we are in an excellent position to tackle this completely previously unknown virus precisely, in record time, by the way, precisely thanks to the patent system. And Dr. Matthews, you mentioned some of the efforts, but I submit that every lead that we have today to treat COVID-19 is a result of a strong IP system that we've had for well over 200 years, as Professor Mossoff said before. In just a few months, as you've pointed out, I'll just speak for Novartis. I mean, there's lots of other efforts going on, but Novartis alone has been able to take 3 compounds and put them into phase 3 clinical studies. So phase 3, we're talking about the tail end of human trials in just a couple of months since this crisis began. This includes medicines that are still on patent, like Jakavi and Ilaris, which are being looked at to treat something called cytokine storm, which is one of the reactions that's actually causing all the respiratory problems in people. We've also been able to test, as you mentioned, hydroxychloroquine. While that is an old compound and that the compound itself is off patent, that was also originally a patented drug. And patents are also enabling our early stage research into all of the many compounds that are looking promising in our compound libraries. And the same, of course, is true for all of our peer companies, including everything you read about. Gilead's remdesivir, another patented drug that was only there to test in the first place as a result of the patent-driven R&D that was undertaken long before this crisis began. Let me turn to collaboration. There's, as I mentioned, an unprecedented amount of collaboration going on to produce treatments and vaccines. There's public-private partnerships, there's private-private partnerships where companies are getting together, where industries are getting together between tech and pharma in some cases. And there's cases where NGOs like the Gates Foundation we're working very closely with them. Novartis, as one company, we're members of the COVID-19 Therapeutics Accelerator, which is organized by the Gates Foundation. IMI, which is a public collaboration with the European government and the private sector, and ACTIVE, which is one between the FDA, CDC, NIH, and the private sector, was just announced about a week or two ago. We and many other companies are members of that too. And far from being a barrier to access, a barrier to collaboration, as some people are alleging, IP is actually proving to be instrumental in facilitating these kinds of collaborative approaches to R&D in this pandemic. So for example, it's allowed us to quickly identify the right partners with the right intellectual assets and expertise to bring them into these consortia to tackle COVID-19. And IP is also allowing us to focus and define the contours of these collaborations in ways that allay concerns about confidentiality and business information, that allow us to deal with prior obligations that might exist around rights. And it therefore frees us up to actually be able to contribute more to these types of collaborations. Let me talk about access also. So the facts also show that IP will not be a barrier to access, fast and broad access to any COVID-19 treatments, and we know they are coming once we have them. It'll actually, IP once again will help to facilitate access. So for one thing, many companies have already stepped up and committed in advance in these special circumstances to voluntary waivers of IP rights and voluntary licensing of their IP rights related to COVID-19. We made an announcement a week or so ago that we are going to voluntarily license and or waive any IP rights around hydroxychloroquine. It's not yet been obviously proven safe or effective, and we'll have to see if that pans out. And yes, the compound itself is old, but let's not forget that the clinical trials that are done here create new data that is protectable by regulatory data protection rights in the ordinary course in the United States. There are patents that come out of the incredible work and investment that has to be done to figure out the right dosing. How do you get this into the body, which may not be the same as the way we use it to treat lupus and malaria. These are inventions too. They are normally, patentable if they meet the patentability criteria, but we have stepped up and said that we will make it available. We've seen similar measures and steps taken by Gilead. They've waived their orphan drug exclusivity for remdesivir. AbbVie waived its patent or voluntarily offered its patent rights for Kaletra recently, and there's lots of other examples as well. And voluntary license is actually, it's really important to have the IP there, because even if you want to use it in this way to promote access in ways that are not the normal course, they're an important tool to help us quickly identify suitable partners that can help us manufacture and distribute COVID-related medicines at the quality and the scale needed in a pandemic situation. What we don't want to do is just open this up to any old person or any old company to manufacture these without any tracing, because then you end up with a counterfeiting situation, which is unfortunately what we're already starting to face. Counterfeiting of some of these medicines that have not yet been approved are at unprecedented levels, and that's a tragedy, and IP can really help there to keep track of the sources if and when we need to ramp up production and make sure that there's enough being made fast enough for the whole world to get. Voluntary licensing will help us partner with those other companies to do that, both generic and other innovators alike. But it's important to note that even in a pandemic, there is no one-size-fits-all approach to IP that is right for every medicine and every company. We need to think about the circumstances of each and every medicine independently, and we need to think about the long-term picture to prepare for the future and future pandemics. So let me just give some quick examples of that. So in many cases, the medicines, I mentioned a few of ours that were previously approved and patented for other uses are now being tested for COVID-19. We need to make sure, even if we are able to take these steps to make these treatments available for COVID-19 without exclusivity, or even giving them away as we have through philanthropy, the 130 million doses of hydroxychloroquine. We need to the extent there are patents in place for some of these medicines that are still on patent, HCQ is not one, but we need to make sure that those rights are respected so that we can use those revenues to reinvest in R&D and keep our R&D model sustainable, so we're ready for not just the next pandemic, but other diseases as well. COVID inventions that are made today also may have applications well beyond COVID-19. We may be testing an untested compound that's brand new that turns out to be a broad antiviral that can be used in lots of different viruses in the future. If that's the case, we want to have incentives in place so that we can invest after this pandemic is done in developing them for those further uses. Another example, we as Novartis and other big companies are fortunate enough to have, thanks to the patent system, we're in a position to keep on investing in R&D, but we're also able in these kinds of situations to really change our normal approach to IP and give up our period of exclusivity in certain cases and to use voluntary licensing and all that. But not every company may be in that position. Smaller companies like startups, maybe a one-product company. They may have been working, and some of them have been working since SARS and MERS on a single product or a single class of products for the last 10 years. And everything they've invested is riding on the ability to make a fair return during a pandemic. And if we take that away categorically across the board for a company like that now, they will not survive to be able to innovate for the next pandemic. And finally, I think the one other thing that we all kind of, many of us assume, myself included, that that if we get a vaccine out of this, we're going to get a jab in the arm, and get a booster like polio, and we're done. But it very well may turn out that we need to do this on an annual basis, like the flu shot. I don't think we know that yet. And if that's the case, we're going to need IP rights to enable people to continue not only to incentivize them to continue to make it at scale every single year for the foreseeable future, but also to continue to improve it, because it's unlikely that the very first iteration of a vaccine or a medicine is going to be perfect. It's going to need to be perfected. More innovation is going to happen around it to make it better and better over the years, and maybe come up with something, a different drug that's even better. So let me just end by reiterating that innovation and collaboration are going to get us out of this pandemic. I think that is without doubt. But for that to happen, we need to be looking at the facts. We need to let the IP system do what it was designed to do and what it has done successfully for 228 plus years. We need to embrace this unprecedented amount of public-private collaboration. And we need to make sure that we're preparing for the next pandemic, even as we work together to put this one behind us. So I'll stop there and turn it back to you. Thanks very much for the opportunity.
Well, thank you, Corey. And Tom, Tom can open it up for questions. So if you want to ask Corey a question, hit the raise hand button and Tom will call on you. And while that takes just a second, Corey, you mentioned the number of, there's a number of companies that are trying several different approaches, including Novartis. Some of these are large companies, some of them are small companies. A lot of those are not going to work. There may be reasonable attempts to try it, but they're not going to work. So you may have a handful, you may only have one or two that comes out that's a vaccine or a treatment or something out of all this millions and millions of invested dollars. And that goes to the point that you're talking about, the amount of money it costs to create a drug. That money that goes in to create the drug, when it starts coming in, that money is used to invest in these things. The industry was able to jump right in here. You didn't have to wait for government approval. You didn't have to get Congress to approve your budget. You were able to jump in immediately and start using that money that was coming in from other drugs to try to find a cure here.
That's exactly right. And thanks for raising that again. And Adam touched on this as well. I mean, the pharma R&D model is such that the failure rate scientifically is so high. It's also pretty high financially. I don't know if this is a fact that's not well appreciated, but studies show that only about 1 in 5 drugs that actually is marketed will even make back the money it costs, to your point, to create in the first place. So 80% of drugs that are sold are actually not even making a return. And we rely on these few successes, not only scientifically, the few that make it, 1 out of 10,000 by some measures, if you look at the early compound stage. But even then, when we sell our drugs, not all of them will make a return at all. And still, we're able to reinvest, something like, on average, I think it's about 14 or 15% across the industry. Novartis is higher than that. We're investing, I think it's about 19% back into R&D every single year, about $10 billion of our own money into R&D. And that is how we fuel the R&D pipeline for the future, and how we're continuing to reinvest what we make back into the pipeline. So it is just so important that this continues. And just one more comment on your question. Absolutely right. A lot of these drugs are going to fail. They're not going to prove, unfortunately, effective, for COVID-19. But still, another reason why we need the IP, because it may be that we actually get some insights into some other research direction from this work. And if we have the IP rights there, we can continue to invest in other research directions to repurpose those for other diseases in the future.
Tom, any questions?
Our presenters must be doing an excellent job today, because we don't have any more questions. So I'm going to suggest, Dr. Matthews, that we move on to our next presenter.
I will then introduce Justin Pine. He's Senior Director of International Affairs, Global IP, and Digital Policy at the Biotechnology Innovation Organization. And Bio, if you go on their website, you will find they've got a podcast up there now about how how one of the companies is looking to attack the coronavirus at its RNA, in essence, destroy the genome. They also have a listing of a number of companies up there that are engaging. I think I saw 16 different companies and what they are doing in the realm of trying to address the coronavirus. So in Bio's coronavirus segment of their website, you can find out what a number of the companies are doing and what they're trying to address right now. So I'll turn it over to Justin.
Great, thank you. Thank you very much for the intro, for the opportunity to share some of my thoughts here with everyone. I'll try to wrap things up here as best I can, and also recognizing the time. I think there are a couple, maybe 3 points I'd like to just underscore. But since you mentioned the Bio website, let me just say it's bio.org. slash coronavirus. So definitely check it out. I think it's not an exhaustive list of biomember companies that are engaged in coronavirus efforts. I think there may be 40 or 50 or so companies on that website, but about a third of our membership, little over a third of our membership of about 1,000 companies are in some way, shape, or form engaging in coronavirus efforts. I think that, first point really is just to underscore how the biopharma sector is focused first and foremost on developing diagnostics, treatments, vaccines to address coronavirus. Massive amounts of resources have been put into these sorts of projects. It's become a significant priority. And the idea is, over the course of years, the biopharmaceutical sector has developed incredible tools, incredible technology, and many of our companies are putting these tools and resources towards developing some sort of treatment or a vaccine for coronavirus, which is great. And we hope that they're all successful. There's certainly a race for innovation, and we want to encourage our companies and scientists globally to unleash their innovation and help us all beat COVID. Should say as well, I'd like to point out another thing you'll find on the bio website is a commitment from our sector to help make drugs and treatments, vaccines available, working with insurers, governments around the world so that patients are able to obtain these treatments and beat COVID globally. Another point, I think Corey and others did a really great job talking about how IP has really helped us get to this position where we can innovate. Again, large and sustained amounts of private investment have really helped to drive innovation in the biotech sector. Not just funding R&D, but investing in critical infrastructure that will allow these innovations to be produced at scale, quality systems here, and allow these innovations essentially to be to reach the global demand. The funding or the incentives to drive the funding for those sorts of for that R&D and for that investment in infrastructure is really because of the strong IP environment that's enabled this sort of investment, private sector investment in our sector. Really, without the IP incentives, there wouldn't be that the ability for the private sector to really drive innovation would be a bit more limited. And I think that certainly, Corey did a great job of talking about the collaborations across businesses, business to business, private sector and public sector collaborations. Every other day, we're hearing news stories. And again, I wanted to underscore the global nature of these efforts. We're seeing companies and public institutions from around the world really collaborate, and IP is a critical tool or enabler for this innovation and partnership to flourish. And I think lastly, with respect to this discussion of IP as a barrier to access, I think that there's other important issues to focus on. I think largely, I think the discussions around IP from the scientist's point of view is quite a distraction from the main goal of beating a very challenging scientific problem that is COVID, but thinking about meeting global demands, logistics, supply chain, quality systems, workers, and manufacturing needed to get treatments globally. That's something that certainly we're focusing on as well. So thinking solely on IP, I think is sort of missing the big picture and the challenges that we all face together as a society. So I'll stop there.
Good, thank you. If you have a question for Justin, or if you thought of one now for Corey, just hit the Ask Question or Raise Your Hand button, and Tom will raise that. Justin, the nature of IP is changing a little bit with the drug industry, isn't it? I mean, you used to be worried more about patents because these are small molecule pills that were being produced. Now we're moving more towards biologics. Data exclusivity has become a major player in there. Comment just a little bit about the evolution of IP protection as the industry changes and moves more towards biologics.
Well, we've been in the biologic space now for many years. I think there are some growing pains in terms of interpreting patent legislation, right? In terms of patent eligible subject matter, here in the U.S., globally as well. But certainly there's a number of sorts of tools. Patents remain incredibly important for biotech innovation, regulatory data protection. There's a number of biotech innovations that perhaps fall out of the realm of patents as well. But I think this is still critical to our sector, to innovation. I think we're all sort of learning and adapting, but I think the patent system has adapted and is adequate for biotech innovation to continue and for the innovations of the future.
Thank you. Tom, do we have any questions?
We have a couple of folks who have asked questions through the chat, which I asked folks not to do, but they've done anyway. They both have to do with China. And so I'm going to float the questions, and I'm going to guess that Adam is in the best position to answer them, but I'm going to invite all of our panelists to participate in the answers if they would like to. Adam, the first question was related to the fact that China has surpassed the United States in the number of patents filed. And the question is, how could we possibly have allowed this to happen? And the second question is related to it sort of builds from that and asks the question, is a government coordinated model like they have in China actually superior to a bottom-up sort of free market model like we have in the United States as far as innovation goes? So I think Adam probably would like to address that, but I'll unmute the mics of all of our panelists in case they also want to respond.
Well, since you prompted me, I will start, but I will certainly defer and leave time for my fellow panelists. Well, as I described in response to Tom's question earlier in our session, the U.S. patent system has really been degraded through attacks on patents as reliable and effective legal rights for up to 10 to 15 years. And there's a lot of causes and reasons for this. It's really difficult to get into in a relatively brief Zoom panel. But the fact of the matter is that is that we live in a global economy and countries pay attention. And so when the United States is eviscerating and undermining the engine that has driven its innovation economy for 220 years in a very effective way, such that other countries have copied it. When we start to then step back from this, other countries pay attention to that and they say, "Here's our chance." And China has done this. In fact, this is kind of a shocking development. I mean, if you had said to any of us, Tom, if I'd said to you 20 years ago that China would have a stronger patent system than the United States, you would have probably thought, "What is Adam drinking?"
Yeah, Adam, I was just thinking that 15 years ago, our focus on China was on piracy and counterfeit.
Yes.
And the discussion 15 years ago was that at some point it will dawn on China that it is in their best interest to innovate rather than to copy. And it seems like they have crossed that threshold in the intervening time.
Well, partially. So it's a process. So it's not like all one step. I mean, so they've still got a culture of piracy. I mean, and this is in part what President Trump has been responding to with the trade war issues, the theft of IP that is state-driven as well, and they still haven't fully, it appears, embraced the notion of patents as reliable and effective property rights that must be secured through the rule of law and with stable political and legal institution. So these are really important complementary institutional and legal frameworks. You can't just build a patent system and then innovators will come. They'll only come if they also can be promised the rule of law in courts and things of this sort. And China is still, in some respects, treating patents as part of its kind of domestic industrial policy agenda. But nonetheless, China is looking to move out of, the BRICS, the second, the upper tier of the developing world, and no longer be a manufacturing economy, but be an innovation economy. And it started to realize that one of the keys to the United States achieving this, from moving from an agrarian society to an advanced industrial capitalistic society, was our patent system, and it's developing that as well. So it's an important key development, and it explains why you are starting to see the innovation occurring in China.
We have a question or a comment from John, but before I acknowledge that, I want to ask, do any of our other panelists want to address that question about China?
Yeah, I'll just say a couple things really quick about the question about collaborations run by government in China. I mean, I think, as Adam said, what you're seeing in China now is that they've come to the realization that the patent system is the best way to try to position China as a world leader in innovation in the biopharma sector, and they're in the process now of strengthening. I should say, even before this phase 1 trade deal, there were movements in China to try to strengthen for pharmaceutical IP for that very reason, not to help us, but to help local companies and to build their IP system and an innovation engine from the ground up. So I think whatever might have happened in the past from government-run research, they've seen the light and moved away from that. Second thing, really quick, I want to mention is that the U.S., I think, in part, it's the patent system for sure that has been such an engine in driving innovation in our field, but it's also, and this is really important, it's also the Bayh-Dole system, which is now, of course, unfortunately under threat. The role for our government that it does best, and that it's been doing since for a very long time, but doing well and practically and efficiently since the 80s with Bayh-Dole, is in basic research. That's what NIH does. It does it quite well. It doesn't do it for every drug, but by any means, but it is doing a lot of early stage research, and it is that system that enables the private sector to step in and actually take that research, invest in developing it, applying it in a practical way, working with universities or small biotechs that have taken some government funding, and turn that into actual medicines. That has been one of the huge key successes, and that what distinguishes the United States from every other place in the world. And that's why you're seeing so much of the innovation that comes out of the US, and why so much R&D is done here. I'll stop there and let the question go to John.
Okay, so any other comments on that question before I take John's question?
Well, Tom, actually, I was going to make a comment on that.
Okay.
I wasn't sure it was the protocol, so I'll lower my hand. Just to say that I'm not going to speak to the situation with the U.S. and as someone said, why the U.S. is falling behind. But one of the reasons that China is jumping ahead is that, as a matter of government policy, they've actually established quotas by province by province, for a certain number of PCT applications need to be filed every year. And so for many years, we got a lot of patents that would come into the system, and we would handle them, but then they never actually went anywhere. They never went back into the national phase because they were just a manifestation of this government policy. They weren't really strong, innovative inventions. They were just paper. But in the current 5-year plan, which I think we're now about halfway through, the 5-year plan of the Chinese government, they've actually shifted their focus from just patents for the sake of patents to actually strong patents that are commercially valuable. And so there's a different kind of incentive being provided by the government to the business community. And so what we're seeing is that there was huge growth in the PCT coming from China for some years, 15 and 18%. It's now fallen back to not so huge, maybe 7-8%, but many, many more of those patents are actually entering the national phase and being pursued as commercial property, which is the change that we see in how China is approaching the PCT. Thanks.
John, that's really interesting and really helpful. Thank you very much. Okay, we have a question from Raphael Farre. So Raphael, please go ahead.
Sure. Actually, I just wanted to stay focused on this question, which is about China. And I wanted to clarify what I meant by a consortium. It's not a government consortium, but rather like companies together, like a corporate consortium. This is what I'm wondering why or when we could produce and create something like this, because we can't wait for a government to do that. Like China has been successful in doing that, but I think as successful companies in America, if we were going to be able to do that and create our own, I wouldn't say a government, but something that is post-government that we can cooperate on, wouldn't we be able to have produce results a lot quicker?
So Raphael, that's the question that I sort of interpreted as the idea of a more top-down coordinated approach rather than a bottom-up competitive approach. And I may have mischaracterized your question. If so, I apologize. All right. Do any of our panelists want to address that?
So
Go ahead, Justin.
Yeah, so just a quick comment on that. I think that oftentimes we can get sidetracked in thinking and playing the baseball numbers game and sort of just, I don't think we want to get into this comparison of patent application numbers. I think it's an interesting metric, but at the end of the day, what we're in the business of is developing meaningful innovations, getting them out to society, improving, mankind, curing diseases, bettering people's lives, and if we can do that and a couple patent applications as opposed to hundreds, I think that it's a fair enough metric. It's an interesting conversation, but at the end of the day, I just want to focus back on, I think we're highly innovative, highly successful despite all of the challenges. A highly innovative, highly successful sector that's really developing treatments and getting them to patients globally. So, I think, I just wanted to highlight that, my perspective for what it's worth.
If I could just add really quickly, yeah, I mean, there actually is a large amount of collaboration that goes on now. It doesn't get the media attention because we haven't had a pandemic until now, but a lot of these consortia work through the Gates Foundation as an organizer, work even with IMI, and in that case, it is a government one in Europe, has been ongoing for years to tackle other diseases. And on the private-to-private basis, there's a lot of work that goes on between individual companies or between smaller groups of companies. But I think the important point is that these are voluntary and they're done based on what makes the most sense for a given project. But we are definitely, as a company, I can say, supportive of open innovation. I think you're going to see a lot of change because of data, big data, and the use of AI. You're going to see companies using that and opening that up to other companies under certain conditions and certain circumstances in the right way too, while also, of course, making sure that we maintain the incentives that are needed to drive that work forward. So I think it's unfortunate. You raise a good point because it's not talked about, but the model that the industry follows is not just, keep everything private and don't collaborate at all. It actually has been moving in the direction of much more collaboration for quite some time.
And I just want to circle back to and riff a little bit off of Corey's earlier remarks and his opening comments about how patents drive actual collaboration and exchange and interaction between people, and that is true of all property rights. Everyone thinks of property rights as stay off my lawn and don't come here, but that's not true. We interact with people all the time with our property rights in all contexts. We do so on our terms and in the circumstances and conditions that makes it possible and feasible and appropriate. And in fact, this has been the case. There are consortia of companies that have existed, as Corey just described, for many decades, and even and going back to the 19th century, patent owners were forming something called patent pools, which are cross-licensing agreements between multiple patent owners that have multiple patents owned by different companies that cover a single product. The very first successful one was on the sewing machine in the 1850s. I'm known as the sewing machine guy in the patent world because one of my favorite articles is on this topic. But this was privately developed by the.
That explains your tie, Adam.
Yeah. So I don't have a sewing machine in my home office, but it's in my office at the law school. I can't go to it. But so and this was privately formed by the individuals because they recognized we should interact with each other. We should license with each other. Biopharmaceutical companies license all the time. This is something that is often not discussed or talked about. They engage in consortium and they engage in commercial exchanges. And so this is in everyone's interest to do this. And this is what drives innovation. It drives economic growth. And this is one of the key features of kind of what Tom mentioned is the bottom-up nature of property rights. Property rights are sometimes can be characterized as a platform, right? All it says is you get to use something, you get to decide the terms under which it can be used. And of course, you want to use it in lots of interesting ways with other people because that produces even more value. And this is what drives our entire economy. And this is as true as property rights and innovations in the biopharma space, drugs, treatments, diagnostic tests, and vaccines, just as much as it is in kind of your more mundane types of property in your bicycle, motorcycle, or car.
Adam, do we run into a problem in this country where what might be called in another country cooperation in this country is called collusion?
So you mean under the antitrust laws?
Right.
Yes, there's always been this tension, unfortunately, between property owners getting together, particularly property owners of intellectual property, and saying let's work together to come up with a better way of getting something faster, cheaper, and more accessible in the marketplace. And antitrust authorities saying, well, this looks like to us like you are hurting competition, you're hurting consumers. Unfortunately, antitrust authorities have through most of our history, have been driven largely by what I think is theories about how they think competition should function and work, and not actually recognizing what's happening on the ground in the real world, and therefore actually have been hurting and undermining patent rights. So for instance, in the 20th century, I mentioned patent pools as something that was formed in the 19th century as a way to eliminate conflicts and to facilitate the fast, efficient, and inexpensive selling of products and services in the marketplace. And in the mid-20th century, the antitrust authority said, well, these are just per se, this is collusion, this is per se an antitrust violation. They took it off the table, actually, as what is a really viable and understandable solution to what is a commercial problem that people came up with a really kind of innovative solution to. So I see antitrust often as a problem that interferes with people's ability to actually get to deploy their products into the marketplace, driven largely by top-down theories, and unfortunately driven by rhetoric sometimes, and not as much as the data and the rights of individuals.
And Adam, that antitrust challenge is even exacerbated here because you have different administrations coming in with different positions. So you might have a strong antitrust administration, and then one coming in that's relaxing those. And as a company, it's hard to know what we do next, because in 4 years or the next election, it may all change.
Exactly. And also, so for instance, and as Corey described, right, you get incredible follow-on innovation, really valuable follow-on innovation, important follow-on innovation that itself requires a lot of ongoing investments of billions of dollars, tens of thousands of labor hours to come up with a new method of deploying an existing drug or figuring out if a new drug works or not. And this is being attacked under this rhetoric called evergreening, which it's not evergreening. This is new follow-on innovation. Thomas Edison did this. He applied for patents that as he develops new innovations on top of his original light bulb and electrical systems and new types of light bulbs and new types of electrical distribution systems. And all innovators do this, including the people in the biopharmaceutical industry, but the antitrust authority is not recognizing those facts, but instead working with a theory of how they think innovation works, which doesn't reflect the actual ground, are now attacking this.
Well, we have no more questions, and we promise to keep this short so that people don't get just completely nauseated at yet another Zoom session. So I think with that, I'll turn it over to Dr. Matthews to wrap up. I want to mention one thing. We will be archiving this video on our website and on our YouTube channel. So if you have enjoyed this and think some of your colleagues and friends should have seen it, you will have the ability to share that link with them. It should be up in a couple of days, and we will email that link out to everyone who RSVP'd for this event. So you will be able to share this content with your friends and colleagues. With that, I'll turn it over to Dr. Matthews.
And thank you, Tom. And I want to thank John Sandage of WIPO, Adam Mossoff, Corey Salzberg, and Justin Pine for joining us as speakers today for a very interesting program on World IP. You can always go to ipi.org. We have share information there. If you want to be on our list, be sure to go to ipi.org and click onto that and let us know you'd like to be on the list. We'd like to thank all our guests for joining us and spending time, and let us know what you think about that at ipi.org. And with that, Tom, let's close it out.